You've got to hold, oh, I'm sorry. You have to hold it down.
Have to hold it down. Okay. Let's call the special meeting of the Cranston Planning Commission to order. The item on our agenda is the comprehensive plan update. So let's begin by, I'll ask the director to introduce the plan and our consultant who will explain more about what we're going to be addressing tonight.
Okay, thank you, Rob. Well, we've been working on this phase one comprehensive plan for several months now, better part of a year with our consultant. As the chapters were submitted, we took feedback and amendments from members of the commission. We've incorporated those into the drafts, as you see. I understand there's still some smaller amendments that we want to entertain tonight. At this point, I think this is a good draft, and we've worked very hard on this internally. So I think that we should feel good about this moving forward. Phase two is going to be a much different process than we followed in phase one, and Ashley can speak to that. But I think we can hand it over to the consultant and just get a sense of where we are as well.
Thanks, Jason. Good evening, everyone. Ashley Sweet with Weston and Sampson. So as Jason said, we've been working on this with you guys for several months, close to a year. When we talked with the city first about how to go about updating this plan, we came up with a two-phased approach. So the phase that you have in front of you is phase one. That has primarily been a data update. We're doing that for the reason in a change in state law. We want you to be able to put in place an updated plan prior to or simultaneous with the expiration of the other plan. The state law says that after 12 years, if it's expired more than 12 years, you can't use it to render a decision on a land use project. We don't want the city to be in that position. So we've done a full data update. We did do an initial workshop where we got some public feedback. We will have a phase two where we will continue to do public outreach. We will have a survey. We will have another public workshop, and we will incorporate, continued public input into the plan. We did not, for primarily touch policy here. We did not get into goals, policies, and actions. You have retained the goals, policies, and actions from your existing plan. Those have been carried over for the most part. We had to add some goals, policies, and actions because there's some requirements that have come into play since your plan was originally drafted. You have to address energy, you have to address natural hazards and climate change. And so we have new data associated with those two chapters and also added goals, policies, and actions. But as I said, the goals, policies, and actions that you've been operating under for previous years stay in place almost in their entirety. There's been very minor tweaks to language that have not really changed the substance of what's in that that implementation plan. And as you pass this along to the council, hopefully the council adopts this, then you'll have an updated plan in place. You'll be able to continue to make land use decisions based on that plan. And we will, without pause, continue into phase two, doing the additional public engagement, and then we'll get into policy and we'll work with the staff and with the commission and the public to refine your goals, policies, and actions. And that's where we would see a change, potentially a change in policy. But the document that's in front of you now does not contemplate a change in overall policy direction for the city at this point. I'm happy to answer any questions now or throughout the public hearing at your request.
Okay, thank you. So
Thanks.
at this point, I'd like to ask any of the commissioners who have comments or questions for Ashley or for the planning staff to ask those questions or make those comments now. Okay. So in the absence of any comments or questions, I think we should have any amendments that are going to be presented from the commission presented at this point so that they're available, they're made known before we take public comment. So does anyone have an amendment to offer? Commissioner Frias.
All right, first I'll start out by saying, most of my major amendments that I suggested to the staff has been adopted in one form or another. And therefore I have basically a couple of minor amendments, and then there's another amendment I'll talk about in a minute. But this one first, is H1. As you see in the goals for chapter 3, it says as appropriate. Why did I put the word as appropriate for that particular goal? It's because it currently exists in our current plan on page 75 of our current plan. Because it's there, I thought we should continue it. The second amendment, now, when I make my motion, I'll make this as a group motion. The E12. Now, the E section is all brand new. So these are all new goals and policies. I personally have some concerns about some of this stuff in here. I personally don't agree with incentives, tax incentives in general for this kind of stuff. And some of these goals I think are rather unrealistic. But I understand, as I've said before, this is not my comp plan. This is the comp plan of the city, and the city consists of people with lots of diverse opinions. So I made one change here, which is transition some municipal fleet vehicles to electric or hybrid models. The reason I did this is that I simply do not think some of our DPW equipment should be electric. Okay, maybe the DPU director disagrees with me, but I looked at the Warwick plan, and the Warwick plan uses this phrase: develop a plan for converting the municipal fleet to fuel efficient and alternative fuel vehicles. So they're not even taking the position that everything should be electric. So I made that change because I think it's realistic, and that's my two minor amendments. Somewhat later, Mr. Chairman, I'd like to hear the other commissioners what they have to say, but I'll be making also an amendment related to the 3 parcels on Alpine Estates. That's a more controversial amendment, so I'd like to take it separately. But if you want, Chairman, I could make an amendment for those 2 minor things I did right now, or you want me to wait for the other people?
So I think the best approach would be to present all the amendments now, take the public comment, so
Okay.
that there can be public comment on the amendments.
Understood.
And then vote on everything as a package, not as a package, the amendments individually.
And then the package
plan
of it.
as amended at the end.
Okay.
So I will ask, are there other commissioners with amendments to offer? Commissioner Zavelis?
Tom, just make sure you use your microphone.
Yep, I have it on. My focus, although Commissioner Frias only hit on one of them, I offered, okay, in the opportunity, and which bleeds over to the goals. So as an example, instead of, the direct participate in, because I don't know what we're getting into, quite honestly, I suggested review the participation in the state incentive program, because I don't know what that entails. Continue on those lines, review the possibility of aligning local policies with the state's renewable energy standards. And Jonas, if you can keep scrolling. So my approach to this, and then perform a cost benefit analysis in implementing energy efficient retrofits, perform a cost benefit analysis in installing renewable energy systems on municipal properties. Further going through, review the possibility of offering incentives for green job creation. So it's more of, you know, approaching each one of those activities and then the related goals after we've done our due diligence on each one of those. So instead of saying, we are going to do this, finances part of this will be working with the related department or, council on each one of these without a definitive saying we're going to do this because we don't, know what it actually entails. This bleeds over to the related goals. So it's a twofold. First, the opportunities, then the goals. So it's a continuation of, actually approaching each one of these with our eyes wide open and knowing what we get into. So I submitted those to the planning department.
And staff has all of the language changes already.
Yes, Chairman, those are reflected on the screen right there, and we have no issues with those.
Okay. Any other committees have an amendment to offer? Commissioner Lanfear.
Thank you, Mr. Chairman. First of all, I did also offer a number of amendments that staff reviewed and incorporated, so I do appreciate that. One of the items, when the final draft came out yesterday, there was a change made, and so staff does not, they have a similar amendment that I offered, but it would be under land use on page 13-9. And it would be I think it's 13-9. Where it talks about the Eastern Cranston and the development of smaller lots. I apologize. I picked up the wrong set of documents when I left the house this afternoon, so I don't have them in front of me. I think it's right at the top where it says Eastern Cranston is largely built out, but may attract new investment in the form of adaptive reuse, comma, the development of, and development of existing, I would strike small lots and replace that with substandard lots of record as appropriate. And I would note that the footnote would remain, and the footnote actually references the state law that describes it as substandard lots of record. Small lots is descriptive, but I think a little too general. And the reason why I would add the wording as appropriate is because obviously state law is something that we're required to follow. And so any actions we take have to be consistent with state law. But there is adding the as appropriate makes clear that there are still some things that a commission may do, and it preserves the discretion that the planning commission may have under state law with respect to what is and is not appropriate, such as conditions and other things that are allowed by state law. So is that clear, or do you want me to repeat just what was stricken and what was added?
So I'll just make sure that the staff has a record of that amendment and the exact language to be changed if the amendment is approved.
Would you like me to write that out and hand?
I would,
Okay, I
to make
apologize.
sure.
I had it printed and for
Yes.
copies for everyone and left it at
All
home.
right. Substandard lots, yes.
All right.
I think what it is you take the word existing, cross it out, keep the word existing, cross out the word small, and in its place put substandard. So,
Substandard lots of record.
yep, substandard, and then after the word lots, put the phrase of record. Another comma, to keep the comma, go as appropriate. comma, and then the rest remains the same.
Yes.
Okay, good, got it?
I,
Okay, do you have another?
I don't have another amendment. I did have some questions with regard to the numbering of some paragraphs and one other change. In one of the paragraphs, and again, I don't have it in front of me. I believe it was the following under current measures where it says land use policy of 9. That's the one. In that, I believe it says by increasing open space, 1, 2, 3, preserving the, it should read existing density, not exiting density. And then I also had a question which I did relay to the staff, so it may be that I don't understand the numbering, but they can correct me on natural hazards and climate change, chapter 12. On the first page, there are a number of bullets, and there they are. And after the bullets, it references section numbers. When you go to those section numbers a little further down, they do not they don't match. I believe current measures may be 12.4. They don't match up. And then as you go to 12.4, I believe it is, it starts with 12.4.2, and then the next one, and I'm having difficulty reading it, I think is 12.4.2, then it goes to 11.4.3 and 11.4.4. So I think there may be an error in the numbering. Okay, that's fine. I just wanted to be sure that they are in order. Okay. And again, the section where the bullets are don't match up as well.
Okay, any other commissioners have an amendment to offer? Okay, then I'll come back to Commissioner Frias for his third amendment.
All right, so this amendment is different from the others. So when the time comes, I'd probably make a motion to adopt all the amendments we've heard so far as one package because I don't believe they're controversial and this one would be a separate. As I mentioned at the last meeting, I was considering putting an amendment that would remove the 3 parcels in the Alpine Estates area that have been has had some controversy over the last decade that are currently recommended to go to A20 that are now at present A80. The page on your PDF is page 208. And at the bottom is, you see parcel plat 35, lot 2, Sage Drive. Plat 35, lot 3, 0 Pippin Orchard Road. Plat 35, lot 13, 0 Pepper Mill Lane. So I'm going to be making an amendment to remove these 3 from this appendix and therefore cause the future land use map also to reflect that these are to stay A80. The reason I'm doing all this, so let me start out with this. I've spoken to the city solicitor. I had a conversation with him, the attorney who was handling this case. Based on my conversation with him, I believe that I can go forward with this without increasing or causing any legal detriment to the city. If you had given me contrary advice, I would not be going forward. So where to begin? Basically, we have received public comment about this. And although just because the public has made a comment doesn't necessarily mean I agree with it. But this has been an issue now in the city for about a decade. On top of it, the city council has not accepted making zone changes on these three parcels. The Peppermill Lane, in 2014, the city council rejected a zone change there. We, in 2019, this commission, I was not present, but they made a negative recommendation for the zone change. And in 2021, I think Peppermill Lane owner tried to make a zone change and then subsequently withdrew. The Sage Drive, they attempted to make a zone change, I believe, in 2019, but withdrew it. In 2021, the city council rejected it by a 7-2 vote. And in 2024, while litigation was ongoing, the city councils did vote in favor of it by a 5-3 vote or 5-2, and the veto was vetoed by the mayor and the veto was sustained. So it's clear to me that it looks like the public officials of the city do not want to make this change. And therefore, I don't understand the logic of continuing to put this in the comp plan and lead to litigation and confusion. That's one aspect and why this is the reason I am doing this. But also, the issue here is the school capacity issue at Orchard Farms. Now, I know my colleagues don't, some of them or planners in general don't think the school capacity issue is that relevant. But I do believe it is a factor. And what I read in the school committee minutes of October 10th, 2023, was that Orchard Farms and Oak Lawn School is at capacity and that there is a need for turning Hope Highlands into an elementary school again, and therefore building a new middle school for $130 million. The reason they gave was because of development in Western Cranston. Now, these parcels going from A80 to A20, is that going to break the system? I'm not sure. I don't think so. But we have a whole bunch of development going on in Western Cranston. Vaughn Lane, in July of this year, we were here. There's a Vaughn Lane project talking about 44 homes. Okay? 44 homes going there. That means it's probably 1.7 kids per home. You're talking 75 kids. If you know a third of them are elementary school age, it's going to be a problem. This is getting a significant issue with school capacity in our western section. When you look at how our city is, the schools are distributed, Orchard Farms is the only elementary school west of 295. So the whole area is being by one elementary school. And there's developments appearing all over the place. Now, the only other closest school is the Oak Lawn School, and they're at maximum capacity, and they're just east of 295. So I have a significant concern about adding more, this A80 to A20 will exacerbate the school capacity issue at Orchard Farms. That is, there are other developments going on there by right. I get all that. But if we have discretion, we should exercise some discretion here and keep it at A80. I saw the letter from the school department of June of 2027. And they're talking about the school has a capacity of 560, Orchard Farms, and that we can just do redistricting. That letter only confused me because in that letter, nowhere did they say, oh, by the way, we're wrong that we need a new middle school. Either we don't need a new middle school because of all the development, or we do. And my goal is to try to avoid more costs for the city when possible and to do intelligent planning. In the 1970s, there was all this criticism I remember reading about like the planning department wouldn't talk to the school department about, and then they would do apartments and there was not enough capacity at the local school. I prefer to have a conversation with the school department and figure out what exactly is the situation out there. And therefore, in the meantime, I'd like to at least move this from the current recommendation A20 to A80. One couple last things. First, the school department had this in their letter, used the word political. To be clear to everybody, including the school department and anyone who's watching or anyone who will quote me in the future, I bring up the school capacity issue for over 2 years, regardless of the project. Legion Bowl, Knights Corner, Printworks, all the time. It's not just Orchard Farms and Alpine Estates. I don't know these people. I'm not running for office over there. I never ran for office over there. All I can say is I have a concern about maintaining adequate capacity for elementary schools. Some people say, well, you just redistrict. Redistricting disrupts children's lives and at the elementary school level. And parents, when I bought my house, I was buying it because I knew where my kids were going. So you also disrupt investor expectations. The counter arguments to this is basically affordability, the need for more housing. The houses that are going on those 3 parcels are basically $1 million homes. If we're talking about $1 million homes, we need to build more $1 million homes for the sake of affordability, then I think we've lost track of what exactly the word affordability means. And then the issue of fairness, which is like, well, all the other homes there are A20. I recognize that, but these properties have been A80 for years. Like when these people, this has been A80 for many, many years. Not like all of a sudden, it's like, oh, we changed the zoning on them. So for those reasons, and I'll finish up with this part, I make this amendment at the appropriate time, Chairman. If the commission adopts it, great. If not, they don't. But if the city council doesn't like it, they can always put these 3 parcels back in that appendix. It's a small change. So if that's what they want, but I think I'm trying to do here is get a handle on what the capacity is of Orchard Farms in our Western elementary schools. Instead of just saying, switch everything, go to A20, and then in a couple of years, we have a significant problem and everybody will turn around and say, well, the planning commission allowed all this to happen. And now we have to pay for our new middle school and there's a whole bunch of problems. So planning is about long-term thinking, and that's why I'm making that amendment the appropriate time. Thank you.
Okay, Commissioner Barbieri.
Thank you. I do hear what you have to say, but I think system is always looking to evolve. And what happens in Western Cranston and what happens in Eastern Cranston and what happens in all of Cranston, to be quite honest with you, a school system is going to evolve. To come up with some speculative and things that could possibly happen, there are a lot of different scenarios that could happen in our city. But a school system will always evolve. That's what's great about a school system, and especially about this one here. My question, I think, would go to our city solicitor here. If we change something from an 880 to an 820, if we do something like that, why don't we do it with other parcels too? Or are we just focusing in on that? Would that open up the gates to do it for other things? Are we creating something that might cost us down the road? Like as Commissioner said, planning ahead. My nervousness comes from doing something like that and singling something like that out. Would that also cause us a problem down the road?
You know, so I mean, a couple of things in this in this instance, by making this amendment, you're actually not changing, because it's currently A80. So it's not making a change. It's not making a change, if that makes sense. So you're keeping it as is, basically. And as you can see, the planning department, the consultant, et cetera, went over these parcels individually, and there has been some changes. So by either changing a parcel or not changing a parcel, there's no precedent that would mandate other parcels being changed or not changed, because, well, you know, each parcel stands on its own merit in this instance where it depends on, you know, what zone it's coming from and what zone it's going to, the size of the parcel, maybe environmental factors, certain other factors that planning department or this commission can take into consideration. So again, the amendment that Mr. Frias is proposing is essentially an amendment not to make a change, but to answer your question, you could, in theory, look at every one of these parcels and make an individual decision on every one of the parcels, and the reason to change it or not change it could be based upon different reasons. You rely on professionals to do the bulk of the work in making, again, a lot of these changes. So, for instance, I don't know why 1800 Situate Avenue is going from an A80 to an S1. Certainly you could ask for an explanation on any one of these, but you're not setting a precedent by making this amendment or a subsequent amendment.
So my follow-up question to that would be let's take what you just used, Situate Avenue. If I had.
I just picked one.
Anyone, let's just take what you had. If I had a building permit in prior to the change, would I be grandfathered underneath that, or would that come?
Yeah, correct. Any vested project, by vested, if the application was complete, if it was a subdivisions, for instance, or, if this commission had granted a subdivision, or if it's a single lot and someone has pulled a building permit, they're vested. They wouldn't be, the city couldn't go back and say, hey, you're no longer in a residential zone, you're in a commercial zone. And there's also a process that a developer we're allowed to change our comprehensive plan 4 times a year. And it hasn't happened much lately, but a couple of years ago, we changed parcels on Oak Lawn Avenue from residential to commercial because in reality, they're commercial parcels. So both the landowner and or the planning department has the right to submit individual changes to the comprehensive plan up to 4 times a year, and it goes through the process. It comes to you guys, comes to the city council. So it's not a static document by any means. And certainly if there was a project, an ongoing project, that would be vested. It wouldn't, the city couldn't stop a building permit or something like that.
Okay, are there other comments or questions from commissioners at this point? Okay, if not, I would like to just ask a question of our staff or our consultant, because at some point, the recommendation was made to convert these lots from A to A20. So what is the rationale, whether it's the rationale for leaving it as is in this plan or the original proposal in the last plan to make this change? What is the planning purpose in recommending that change?
Thank you, Mr. Chairman. Well, now during this phase 1, we were very clear that we weren't going to change policy. So this was the policy from the last plan to make these lots consistent with Alpine Estates. Alpine Estates is zoned A20. These lots are internally accessed through that neighborhood. This was vetted by the commission's predecessors, and they felt that A20 was appropriate and consistent with A20. We've had applicants try to exercise their rights with the comp plan and with no success in this neighborhood. Pepper Mill was the first, Sage was the second one, and the third lot has not had any action on it. We've heard the arguments for several years about the increased density is going to damage the neighborhood or city services. The idea of the school capacity issue, it's usually something the commission doesn't touch. It's, when we do land development projects, by right projects, it's not something that's even part of the findings of fact when we do our recommendations, because the school committee is dynamic and the school system evolves, as Commissioner Barberry said. So we don't really bring these arguments into the discussion at this kind of granular level, especially for something we're talking, a handful of houses, in one neighborhood. So staff is not inclined to make a recommendation to change those, and it has not in the past. We've stuck with that recommendation, but we understand it's the will of the policymakers at this point.
Right, so at the base of the issue is consistency with the neighboring, with the neighborhood, essentially.
That's pretty core.
Thank
Yeah.
you. Okay, do we have other comments at this point, or are we in a position now to open up to public comment? Commissioners, anyone else? Okay, let's open up the first public comment from those present in the room. Please state your name and address for our record.
Good evening. My name is Peter Squires. I'm an attorney with the law firm Ursulo Tights and Rich in Providence. I represent a group of homeowners in Alpine Estates, and I've been asked to come to speak in favor of the amendment that was proposed by Member Frias, Commissioner Frias. I'll be short, not to take up too much of your time. I agree with much of what he said, but I'd add just a couple of additional points. The first being that obviously the purpose of this footnote in your comprehensive plan, this part of your appendix, is to increase the density in that area. And that's been in your plan for some time. And it's gone, as Commissioner Frias has noted, it's gone before the council a number of times, but it's never been amended. But there has been a drastic overhaul of the state's land use laws as of January 1st of this year, such that there will be a drastic increase in density by state law, which municipalities, including Cranston, can't do anything about. So just to give an example, every lot that is 20,000 square feet or larger can, by right, have either an attached or detached accessory structure, accessory dwelling unit. So in an A80 zone, where the lots are going to be more than 20,000 square feet, where previously this was recommending to increase the density, it anticipated increasing it to a single family house lot. Every single family house lot now in that zone will support two families and a primary dwelling structure and either an attached or detached accessory dwelling structure. So I'm not going to comment on the policy considerations of the General Assembly. I just want you to be aware that the request for an increase in density that's a vestige of this plan that's been in there for some time, there's already going to be an increase in density. And there's nothing that the municipal level can do to stop that, because that's going to be from state law. So I think that alone would merit approaching this differently, just to anticipate the increased density that's going to be forced upon you by state law. So just to touch on some of the other issues, as Commissioner Frias noted, this has come from the council with different parcels, with different proposals to go from A80 to A20 a number of times over the years, over a decade. I don't think there's any dispute about that. And what I would echo and agree with is that if the members of the council that are elected to respond to constituents do not want to implement this policy, then I don't think that's a realistic policy to put in your future land use map. I don't think it's good sense to be at cross purposes with the elected officials that are actually going to implement the policy when creating a long-term policy for the city. A couple other points. It was mentioned that your solicitor doesn't think it would have any legal impact on pending litigation. Just for any members of the commission that are unaware, There is a lawsuit pending from one of the developers because it wasn't, this parcel wasn't rezoned from A80 to A20. I would echo that. I completely agree with the advice given by your solicitor that there is no litigation or litigation impact to the town that that would be affected by your decision to address this issue. Now, when you're sitting as a planning board considering to update the comprehensive plan, and ultimately when it goes to the city council, you're sitting in a legislative capacity, and there is a whole host of legal doctrines that insulate you in making this decision, because ultimately your thought process should be guided by what you think is good policy for the town, and not out of fear of what a developer might do to try to bring a litigation to prevent you from considering that. So just to reiterate, there's already going to be an increase in density from state law. So I think you need to anticipate that and react to that. I agree with your solicitor that this wouldn't have any litigation impacts or negative impacts on the town. And ultimately, this is something that has gone before your council a number of times, but there has never been the will of the policymakers to actually change this from A80 to A20. And then finally, one last point I'd make is that in the Comprehensive Planning and Land Use Act, when it comes to updating and re-amending your comprehensive plan, unlike the zoning ordinance, where the Zoning Enabling Act expressly says, members of the public can come in and file their own proposed amendments, and you can make a recommendation, either up or down or neutral, and either way it goes on to the council. That's how it works for a zoning ordinance. But for the comprehensive plan, it states, and I'll quote, a planning board or commission has the sole responsibility for performing all those acts necessary to prepare a comprehensive plan for a municipality. So I think what that language does is that you have a much larger role when you're dealing with a comprehensive plan, because ultimately this is the body that's responsible for putting it together and sending it on to the council, whereas individual members of the public, such as these residents at Alpine Estate, we can't push something to the council on our own to consider a comprehensive plan without it coming to the planning board. So based on that, because we think it would be good policy and we agree with the comments made by Commissioner Frias, we'd ask that you consider this amendment. We'd ask that you make that amendment a proposal to the council. And as Member Frias ultimately said, it would be up to the council to decide, and they can decide, but I think it's a good first step to send it along. Thank you.
Okay, thank you.
Thank you. And if I could just reiterate briefly on that, within the ADU statute, there was another line that said, even if your neighborhood restrictions and covenants prohibited accessory dwelling units, they're now void as against public policy. So the legislature just basically rolled over anyone's property rights whatsoever. And those restrictions no longer would apply for accessory dwelling units.
My name is Janice Cataldo. I live on Sage Drive in Cranston. Thank you for the chance to speak to you today. I represent many neighbors who would approve of this amendment to take those areas out of Alpine, the zone changes out of Alpine. Every few months, there is new Western Cranston development, and this has been going on for 30 years. There's no way you can stop it because it's zoned A80, but you can stop this. Hope Road, Phoenix Avenue, Pippin Orchard, late at night, constantly, new development, new development. It's not going to slow down. So why would we want to change to allow more development and a zone change to allow more houses? While the comprehensive plan says, and I quote, the preservation of existing undeveloped land, capacity and traffic are Western Cranston's largest concern. The residents don't want this zone change. There's little, and if any benefit. Yes, there's some, it does coordinate, it does coincide with the land, the A80, the A20 already in Alpine, but there are A80 lots in Alpine. in Pine Ridge, and those houses sell right away. So there's no need, and it's right in Alpine. There's no need to make this land coordinate with what Alpine when you have parts of Alpine that are over our A80. I said there was no benefit to the city. So what is a negative impact? Maybe this commission doesn't care about the school committee and its overcrowding, but you do care about the budget. I hope you care about the budget. And the question about the school capacity, I spoke to people at the Department of Education who are willing to show you emails saying the capacity at Orchard Farms is not the numbers that we just got from the school committee. The capacity is, it is over capacity. The PTO president, the school committee, and parents have all said the school is over capacity. So those are the facts. In the Department of Ed, when they built that school, they set what the capacity level should be. So what are the other negative impacts? Taxes, traffic. The town is thinking of putting a traffic light outside of Alpine, flooding. I mean, those are things, those are issues that the Planning Commission does care about. And the preservation of Weston Cranston. Thank you again for your time.
Thank you. Sir.
Vin McChrystal, 65 Sage Drive. I'm not going to repeat everything that's been said here. I think it's been said very well. I just want to say that I support the amendment, would like to have it taken out. And I just want to make just a general comment that I've made before, is I really don't think that residential zoning changes should be done in the comprehensive plan. I mean, you can see the audience that's here tonight. Most people in this city don't know this is happening. Most people don't realize the impact it's going to have on them in the residential zoning changes. The comprehensive plan to me should be for big things. And, you know, we talk about energy and historic development and other things. It really shouldn't be about changing residential zoning because you're not notifying the neighbors. When this was changed, we weren't notified. We didn't know this was going in. If you go back and look at the plan, it actually says at the request of the developers, and then they list it. No one came to us and told us this was happening. And yet, once it's in the comprehensive plan, it's really difficult to fight it. And we've been fighting this for decades now. So just as a general comment, I would take every residential zoning change out of the comprehensive plan and not let it in until you notify the neighbors and you can have an intelligent discussion with the neighbors about what you're trying to do. Thank you.
Okay, is there anyone else present who would like to speak? Okay, is there?
Hi, Mr. Chairman, I'm Sam Brusco of 11 Alhambra Circle. Okay, so I reviewed closely chapters 9 and 11. I've been in the energy industry for 5.5 years. I go well beyond the solar that I sell. I know this stuff. I'm also a amateur traffic engineer for the last 30 years. Okay, so chapter 9. What we have here, it pretty much just talks about solar farms. And I was left wondering, what about the roofs that are already on developed land, some of which the city owns? I know that there are some solar panels on Cranston West. I don't know of any other city building that has solar panels. Let me see. I also think that chapter 9 has too much emphasis on traffic. And I'm afraid that too much time and money is going to be spent on saving single occupancy vehicles a couple of minutes each day. I was just at a RIPTA meeting last night. They have big changes coming with like hubs in each city and town in the state. So that needs to be worked into this. Cranston absolutely needs a crosstown bus. There is no way to get from one side of the city to the other without taking a car. It just isn't. It would take you at least an hour. Let me see. So also we need protected bike lanes. For every person who is on a bike or on foot, that's one less car that's on the road. Okay, so DPW does an excellent job of removing snow from every square foot of the 400 miles of roads which we have in the city. Thank you, Justin. However, snow and ice removal from sidewalks seems to be absolutely non-existent. Is there anything that the city does except for city buildings?
The city shovels the sidewalks in front of city-owned buildings. correct?
Okay.
Property owners are responsible in front of their houses.
All right, and there is already an ordinance for property owners to make it, safe, snow-free, ice-free. Not enforced as far as I know, at all. And in the winter, parents drive their kids to school because of this. Park Avenue doesn't move on snowy mornings. And that hits most of the schools in the city, from Rhodes all the way over to Cranston West. And that, again, it multiplies the traffic anywhere in the city near a school on winter mornings. Not just the day that is snowing, but for days after that. Page 9-8, oh, a couple of misspellings. I can submit this stuff in writing. Oh, it says dense residential and commercial areas are ideal for rooftop solar. No. Every roof that face east, west, north, south, whatever, as long as it's not surrounded by trees, is actually good for solar. And that's because, not because we have magic sun rays, it's because we have the highest electricity rates in the country consistently. And there's reasons for that, but I won't go into it. There's mention of community solar. That's not going to fly unless there is what I call the fill the roof law done in Rhode Island. And it's because Rhode Island Energy doesn't allow it. If you want solar on your house, you have to stay within the last 3 years of that building's usage. We're supposed to be looking forward, not backwards. And EVs already have a lower cost of ownership overall than gasoline engines already. Of course, there are going to be pieces of equipment that DPW owns, the fire department, and not yet, as you said. Okay, chapter 11. The whole thing is written like a brochure. That was the taste that I got out of it. And it says page 11:1, East Cranston is not urban. It says that East Cranston is urban. No, it isn't. Nowhere in the city is urban. It's suburban. You might call parts rural, but nowhere is urban unless there's some definition that I don't know of. And there also mention of West Cranston being agricultural. Are there any farms left over there? There are? Oh, okay. I didn't know about them. So again, in general, if you don't have a car in Cranston, you're not going anywhere. You can walk to whatever's closest to you, but that's it. And for instance, my mother lived right down here 40, 50 years, I don't know. The last 3 years of her life, she had to give up driving. She couldn't get to the supermarket because it would have killed her. And she only lived 0.6 miles from the nearest supermarket. Page 11:3 mentions mixed-use development. Is that 5 or 6 stories? Because otherwise it's kind of pointless. Transit-oriented development would be better. And again, I refer you back to what RIPTA has planned for the cities. it says on page 11 -3, the city's transportation network is designed to accommodate a wide range of commuting. Again, no, it is not. If you have a car, you can get somewhere. If you don't, you're staying home. Or you have to get a ride with somebody. Which actually doubles that amount of traffic because somebody has to drop you off and then come back. Unsafe or non-existent sidewalks contribute greatly to morning traffic, as I mentioned, for the schools. And on page 11-6, 11.2.2, it does not mention specifically that alternate mobility, bicycling, walking, it all improves our health. We sit too much, basically, as we're doing right now. I thank you for your time.
Okay, thank you. Is there anyone online who is waiting to make a comment?
Drake Patton.
Okay, please go ahead.
Hi, Drake Patton, 684 Natick Ave. First, I want to thank you all for the work you've been doing on this. It's exciting to think that we might make our deadline. And I really am just trying to confirm. I did send, I spoke recently and Mr. Pizzullo made some changes, but I want to make sure that he did receive a clarification on our farm, which is included under open space, and it lists us as not being open to the public. We are during programs, and we do not have a shop on site. And that's important because the city has recently decided to change our use code to commercial mixed use, which effectively pulls us out of a farm program, which is run by the state. So it's created quite a complicated situation for us. So for the purposes of this comp plan update, I would like it if that could read correctly, because it's quite important to us in the moment. But again, thank you for the work on this. And I would say that the last speaker, I didn't plan to speak on transportation, but boy, is it a place we need help. And as someone who lives on the west side and would love to be taking public transportation, it is not an option. So let's hope RIPTA can get it together. Thank you so much.
Okay, thank you. Is there anyone else online to make a comment?
Karen Rosenberg.
Okay, please go ahead.
Hi, Karen Rosenberg, 46 Bow Street. I have some comments regarding a few different parts of the draft. And I was going by the draft that was on the website today, so I hope that that's still the current one we're talking about. I wanted to start by noting that the draft has 6 places in it where it mentions that there were stakeholder and resident interviews that informed the plan. And I guess my question is, why is there an appendix, or shouldn't there be an appendix or something where the stakeholders and residents are identified? Who are they? What did they say? Is that laid out any place in the plan? And then I wanted to sort of tie that into some comments regarding some mentions of the Budlong Pool in various places in the plan. The first one is on page 15, where the statement is made that reconstruction of the Budlong Pool is intended to serve all segments of the population. I don't know what the basis is for that statement. And I think that a lot of people would strongly disagree with that statement. This was a pool that is capacious and has been historically inviting to people of all ages and all different uses, and it's being shrunk down and made shallow. The designer admitted that it was not designed to appeal to teens, and the dimensions of the pool are not appealing to teens. It's mostly been designed apparently for small children. So I think a lot of people would really dispute that characterization, and many people have specifically characterized this as a resort style pool that they didn't want. So again, this kind of ties back to who, where are the sources for this information? Statements that are just sort of, there with no sourcing are not legitimate. Another place where the pool is mentioned is on page 111, where there's a paragraph which says the pool is now at the center of discussions regarding its future. Officials have developed a redesign to better align with contemporary usage patterns and financial sustainability. And it also says that the proposed redesign aims to create a sustainable and enjoyable recreational space. The outcome of this process will ultimately reflect the community's values and vision for the future. This, again, is sort of bewildering. The statement that it was designed to align with contemporary usage patterns and financial sustainability really isn't borne out by the record. There was never an independent assessment done of the condition of this pool, and the design was pushed through based on false and unsubstantiated assertions about its condition. There is no evidence that the pool was in need of replacement. There was only an assessment done by somebody who was hired to design a new pool and gave this assessment many months after that contract was entered into. And the city has admitted that it really has no credible evidence that the pool was leaking. It doesn't have a written estimate of the cost, of a cost breakdown of what would be required to preserve and continue to operate the pool. There's just, this is a problematic and unsupportable statement. There was also false and misleading information presented when the pool plan was being pushed through about the historic usage that was based on flawed and incomplete information. It didn't account for camp usage of the pool. It misrepresented the pool's capacity as being 1,200 swimmers when the city limited the capacity to 300 swimmers. And there was often more people who wanted to use the pool, but they couldn't get in when it had reached capacity. There was really no information presented publicly concerning questions of financial sustainability, and there was no public debate on that question. There are audited budgets that show that the pool was not particularly expensive. It netted revenue from pool passes. It served a camp program, and it provided jobs for city youth. These are questions that really could have merited a vigorous public debate, but there really never was one. There was no public discussion preceding the mayor's unilateral decision to replace the pool. He announced it in the spring of 2023, and that unleashed overwhelming public opposition, which was just ignored. So it's really not true to say that this decision reflects the community's values and vision for the future. There was another mention of the pool at page 125 in section 8.31 that talks about, it says there was debate about the size and scope of the new pool. Community expectations varied, with some advocating for a pool that matches the size of the original, while others supported a small, more cost-effective option. Not true. And it goes on to say the closure of the pool was a contentious issue, but the final design balances community desires with financial feasibility. Again, this is just not an accurate reflection of what occurred. Look at the public record. There was virtually no members of the public that ever expressed support for replacing or downsizing the pool. There was no discussion about financial feasibility. And there was overwhelming opposition to the pool. More than 2,000 Cranston residents signed a petition opposing the plan. Well over 100 spoke against it at public meetings. There was almost nobody on the other side of this discussion, and the final design was overwhelmingly rejected by the public. So this is a whitewashing of this issue that doesn't really reflect reality. The other section that I wanted to comment on is community engagement. And there's a couple of mentions regarding community engagement, which is a very important, essential component of developing a updated comprehensive plan. And I understand that there's going to be a phase 2, and that, you know, there were supposedly not meant to be substantive changes in phase 1, and there was, you know, intended to be very limited public engagement, but still it seems that what is described regarding that public engagement is not accurate. On page 6, section 1.6, there's a statement: the city of Cranston recognizes that community engagement is a cornerstone of a successful planning process. Community engagement is critical to ensuring that the public supports the goals, policies, and actions of the comprehensive plan, and it should reflect the needs and desires of the citizens of Cranston. It goes on to say various techniques were employed to ensure broad and inclusive participation in the development of the plan, and it describes a public forum and workshops and a dedicated project website. First of all, there was not broad and inclusive participation. If you're speaking about, you know, what may happen in the future, that's one thing, but it's just deeply inaccurate to say that there's been broad and inclusive participation at this stage. There's discussion about public forums and workshops. There's a mention that there were a series of public events. No, there were not a series of public events. It mentions one public forum that was held in September 2023. And it says the results of the public engagement events are contained in Appendix A. Appendix A has nothing to do with public engagement. Appendix A is about zoning. So that's just inaccurate, and that should be corrected. But in September 2023, there was an approximately 1-hour presentation by the consultants that was essentially laid out a timetable and a description of how this process was going to go. That was not a public engagement event. So that's a mischaracterization. There was one public engagement event that is not mentioned in this document at all. It happened in February 2024, and it was really a 1.5 or 2 hour maybe event that was attended by, I would estimate, 30 members of the public who were invited to circulate between 4 or 5 tables, each meant to represent one or multiple topics covered by the comp plan. We were invited to, with really no framing of the issues, we're invited to write on sticky tabs ideas about what we liked or didn't like within those subject topics. Those sticky tabs were collected and common themes were summarized by the facilitators. I don't see anything about the results of that event summarized anywhere in this document, but I would say that if that was supposed to elicit meaningful public input into planning policy, that's just, to me, that's just absurd. I worry that this is what the commission or the department or the consultants think right now constitutes meaningful citizen participation, and that this is sort of the level that's contemplated in phase 2, because the plan mentions, or the September 2023 event anyway, mentioned that there would be one or two events like that one in phase 2. That is deeply, deeply concerning. And what really is needed is much, much more than that, starting with extensive public education so that members of the community understand the problems and the different policy options that exist to address them. This involves meeting people where they are in the community. Providence did 2 years of this kind of work, often at the neighborhood level, before it produced its new plan. Our plan update is now 4 years overdue. The city needs to invest in real, meaningful civic participation before it will be able to claim that this plan reflects the aspirations and values of the Cranston community. That's, a quote, because right now it does not. I also want to note that the section on page 6, section 1.6, also talks about sort of technological tools for public engagement. It mentions a dedicated project website serving as a central hub for project information, updates, and engagement tools. And it says the website includes a project status board, timeline, graphics, interactive maps, and tools for public feedback. I looked at that website today and it includes none of that. This is grossly inaccurate information. The only thing that's on that website right now is a form for people to submit questions or comments. No context, just a blank page with a form that says you can fill it out and submit your question or comment. I actually did submit a question through that form many, many months ago, asking for clarification about the timelines for this process, and I did not receive any response to that. So I think this entire section is misleading, inaccurate, and really, begs for the city to consider a much more robust public engagement plan. It's going to require an investment in resources, but this kind of, hold a workshop and, kind of pretend to give people some kind of input while really not giving them the structure, the information to do that, is just really a disservice to this city that's already many, many years behind in developing a new plan for the next 20 years. Thank you.
Okay, thank you for your comments. Is there anyone else online?
Douglas Stowe.
Mr. Doe, please go ahead.
Oh, thank you. First, I'd like to thank the consultants for revising the energy chapter in line with Commissioner Frias's comments at the previous meeting. They were much needed. Second, there's numerous references to the Conservation Commission. Unfortunately, Cranston does not have a functioning Conservation Commission. The last meeting agenda posted to the Secretary of State's website is December 2020, nearly 4 years ago. For some reason, the mayor has failed to appoint the necessary members so they can actually operate. So that's got to happen before anything else happens. Third, I appreciate the references to the West Bay Land Trust. We're a very small group, all volunteers, but we've accomplished quite a bit over the years. Our next major project is developing a draft management plan for the Knight Farm Conservation Area. That should have been done about 20 years ago, but better late than never. And I'd like to correct 2 mistakes on the land use classification chart for Plat 23, lots 9 and 16 on Burlingame Ave. Right now, they're listed going from 880 to 820. They should be going from 880 to open space S1. Lot 9 is actually just a forest swamp. So no one's gonna be building houses in there. Plus it would be illegal anyway. So if you make those changes, and again, I appreciate all the hard work that's been put into this plan. Thank you.
Okay, thank you. Is there anyone else?
I'm seeing no new public comment.
Okay. If everyone in the room has had an opportunity and everyone online has had an opportunity to make comment, I'd take a motion to close public comment. Commissioner Zadelis, second. Commissioner Matus, seconded. All in favor? Any opposed? Okay, so I think at this point, the proper order would be to have any discussion. I like Commissioner Frias's suggestion that we vote on a number of the amendments in a block and then save his third amendment for a separate vote. So if that works for the commissioners, I would ask if there's any comment on the first set of amendments, which I'll just run through quickly to make sure everybody remembers them. Commissioner Frias had two amendments, which were very minor changes to the language in the housing and energy sections. Commissioner Zadelis had submitted some changes to the language concerning renewable energy, investigating, looking into the options for renewable energy and the goals for renewable energy. Commissioner Lanfear had an amendment concerning specific language related to substandard lots of record as appropriate in the land use section. So I would ask if anyone, as well as a couple of typos that I think are just typographical things that don't necessarily need a vote. They were just pointed out to staff and to the consultant. So if anybody has any questions about that, and if not, is there a motion to approve those amendments as in a block?
I make a motion to approve this evening's amendment in a block.
And second, Commissioner Exter, all in favor?
Aye.
Any opposed? Okay, so as a separate issue now, we'll address Commissioner Frias's third amendment, which would be to remove from the list of proposed changes in the land use classification, the three parcels in the vicinity of Alpine Estates. The current plan as it stands proposes to change these from A80 to A20, and Commissioner Frias has made an amendment to strike those three parcels from this chart, and in doing so would remove those changes from the future land use map. Is there any comment on or discussion on that amendment? Okay, hearing none, I would say I will just explain my own intent. I am not going to support this amendment. I've made this comment before. You know, the fact that Western Cranston has probably hundreds of lots worth of land that is zoned for development by right, and a handful of other parcels is not going to change what happens to realignment of schools when we have potentially hundreds more houses being built, which will require all kinds of city services in addition to schools. And if we start making decisions about planning and land use because more houses may require more city services, then, you know, I think we're going to get stuck making decisions that aren't based on planning, but based on either finances or other issues. So I just want to explain my own intention to vote. And is there a motion to approve this amendment? Commissioner Frias makes a motion. Is there a second? Commissioner Lanfear seconds. All in favor?
Aye.
Any opposed? Nay. The amendment is approved. So now, at this point, I believe the next step would be to approve the proposal as amended by this body.
Correct.
Is
Yeah,
that correct?
correct.
Could I just make a quick comment before we just, I have no more amendments, people. Don't worry about it.
But you do have a comment.
I do have a comment, unfortunately. I just want to thank all the public comment we received today. I usually like addressing the public comment I heard. I think Ms. Rosenberg made some points. I hope as this goes to the city council, if there's some typographical errors or issues like that, I think it should be, if we can fix it before we go to the city council, I'd really appreciate that. I'm looking at the consultant and the director on that. And, this will go to the council and the council will make some possible wording changes about certain things. We'll see what happens. But if I had a little bit, what I want to say to the public here, we are under the gun of state law of trying to get a plan in place like in the next 30 or so days. And so that's why we have a phase 2, to get more public engagement, to refine some of these things and to put more stuff in. I do listen to public comment. I take into account, I don't always agree with what I hear, and I let you know why, unfortunately. But I just want to let the people who took the time to speak, you will be heard and will be considered. And this is a process, but we have to get something in now. And the last comment I will say is, as I said earlier, this is a community that has a lot of diverse opinions. And what I focused on are the issues that were most important to me, which was protecting our residential neighborhoods, maintaining the existing density, and making sure that we have Cranston as a place where people who have different choices they want to live, whether it's rural, suburban, or urban, have that choice. And in this plan, lastly, we've referred to Cranston as a suburb with a distinct suburban community. That is something I have strongly believe in. It's something when I first got appointed, I told the planning staff that was a reason why I agreed to this appointment, was to make sure our comprehensive plan kept that. Because Cranston has referred to itself and considered itself since adoption of zoning 100 years ago as a suburb. And I'm happy that I have continued that to the best of my abilities. So thank you very much for that quick speech, and I have nothing more to say.
Any other commissioners like to make a comment at this point? Okay, then I would ask for a motion to approve the plan as amended this evening. Commissioner Price.
Aye.
Mr. Chairman, thank you. Thank you, everyone, for moving this to the next phase. Just a quick note, our next meeting is coming up on Tuesday. I had to, in abundance of caution, I put this as an agenda item on Tuesday in case we didn't get finished. So even though it's on the agenda, I had to post it before this meeting started, but there will be no discussion on the comp plan at the September 3rd meeting. Just want to let everybody know that.
Thank you very much. If there's nothing else, is there a motion to adjourn?
No,
Oh, I'm sorry.
I'm sorry. I'm not going to prolong. It's just a question. Can the commissioners be sent a copy of the final plan as soon as it's prepared so that we can take a look at it and make sure that, as another set of eyes, to be sure that there aren't anything that needs to be brought to your attention?
Yes, we will post it to the website. We're going to try to stop with the endless cycles of revisions. It's gotten very, very confusing over the past few months trying to keep all this straight. Yes, that when we pull this all together and try to do the final cleanup with Ashley, that will go out there. I'm going to work with the council, as early as tomorrow and start talking about calendar, about how we're going to get into the advertising of this, because we are under the gun. This is not something we're going to do more revisions at this point. Yeah, 30 days. I hope anybody doesn't expect 30 days where we'll have a plan approved by the city council. But we're, sometime in October, probably, we'll have a hearing from the city council. So that's where we are right now.
Okay, so just a note, our next meeting is Tuesday, as the director mentioned, at our regular time of 6:30. And is there a motion to adjourn? Second? All in favor? We're adjourned. Thanks, everybody.